President, Manipur Architects Forum, to kindly facilitate our moderator, Dr. C.H. Priyoranjan Singh, Professor and Head of Economics Department, Manipur University. Oh, so please take the dais. Thank you, sir. Now I would like to hand over the mic to our moderator, Dr. C.H. Priyoranjan Singh, to start off with the technical session.
Hello. So, good morning, ladies and gentlemen. To be honest, I'm not an expert. I'm an economist. But somehow, my friend Kit Kumar was able to persuade me to be amongst you and to moderate the talk, a very important talk by our guest here, Mr. Deepak Kumar. Now, just to introduce ourselves to what really we should be addressing. You see, after my friend Git Kumar told me, come on, you just have to moderate and try to reach the pulse of the people, people of Manipur who want to build houses and what should be their concerns. Yesterday night, I was just going through this Architects Act and all that, just cursorily. And when I looked at the, Supreme Court's ruling, I suddenly realized that there's a lot of problem in understanding the profession of the architects in the Indian context. At least personally, the court has its own idea, but I personally felt, that the responsibility of the architect has been somehow, in so many ways, diluted to an extent where, many fly-by-night people, are taking the responsibility of building houses, buildings, constructions, whatever, I felt a little uneasy, that our act, I don't know how it identifies with India's context. With that, let us listen to Mr. Deepak Kumar, a administrative officer. He'll be talking about who is an architect, what will be the norms or practices that we have to follow as architects, what are the ethical and moral principles that we should follow, which we know, at least in Manipur, much of the ethical and moral parts are missing, probably because of what I hinted at, when you don't give the specialist the responsibility, many foul things can happen. And I'm sure Mr. Deepak Kumar is going to deal with these nuances, where in Manipur, as even the builder, what we call the Boro Mistri, he has become an architect. And we have seen a very, I should say, sometimes I would say it is even criminal that pure civil engineers, acting like architects. Can you imagine my university? The type of boxes that you see as university buildings. Someone was telling us how we are missing the aesthetics, the character in our university or in any government building. These are results of unscrupulous people taking advantage of our Architects Act, whatever. I leave it to Mr. Dupak Kumar to go not only into the basic rules or practices, but into the nuances, that has reduced architects to, not on equal terms like advocates or medical practitioners, and I'm sure he will do justice to that. Mr. Deepak, please take the mic.
Thank you so much, and welcome back to this second session on the Architects Act and all nuances related to the practice of architecture. Architects Act was enacted by the Parliament of India under NT 66 List 1 as well as NT 26 of List 3 concurrent list of the 7th Schedule of Constitution of India. It came into force on the 1st September 1972. And we are celebrating Golden Jubilee year of enactment of our Act in this year. The Council came into existence on 31st December 1973. This is the Act and the notifications which were issued by the Government of India about the Architects Act. The objects and purposes of the Architects Act. It is on twin. One is education, another is related to education. The first, I will deal with education to prescribe a schedule of recognized qualifications, which a person, if he possesses that qualification, he becomes an architect. The council will decide a person who can seek admission in architecture course, to inspect architectural institutions, to recommend recognition of an unrecognized Indian and foreign qualification, to prescribe minimum standards of architectural education for imparting recognized qualification, duration of course of studies and all that. And if a qualification is not meeting the norms, then council should recommend derecognition of such a qualification. Now the profession, who is an architect? A person who is registered with the Council of Architecture is an architect. There is no definition of the word architecture and like other act, like legal, medicine, where it is given that a person who practices medicine is an architect. Here merely registration as an architect have been given as a definition of the architect. And the Act says that only a person registered as an architect practices as an architect. So the issue here is, one is practicing as an architect and another is practicing architecture. The Act has been basically there is a lacuna about practice of architecture. Practicing as an architect is there, the restriction is there, but practicing architecture as a whole, it is not there. The Act only says a person who is registered with the Council of Architecture is an architect. It doesn't say only he can practice as an architect. Stop on re-registration of architects by different local bodies. A person who is registered as an architect is not required to get himself or herself registered with any local body. It is an all India registration. We have medical council, bar council who have state offices. So a Council of Architecture is only having a national office and there is no state-wise councils. Prescription of code of conduct and ethics for architects for practicing the profession and punishment for violation of code of conduct. The council has prescribed a code of conduct and ethics for architects and all architects have to adhere to that. Then prohibition on views of title and style of architect. This is the main theme of our workshop today. The Act says any person who is registered as an architect can only use the title and style of architect or a partnership form. Form means where all partners are registered architects. And there is a penalty or fine for misrepresentation because it is a punishable offense. Only registered architects shall be appointed in central, state government, local and other bodies which are funded by central or other governments on architectural posts. Then registration of architects. We have a register of architects where names and address of all registered architects are there. Then the functions of council to recommend the recognition of qualification. Then inspections of architectural institution. We are conducting national aptitude tests in architecture to assess the eligibility of a candidate for admission to architecture course. We are also publishing a directory which is having details of all registered architect in a handbook which contains all the rules, regulations, important judgments, circulars relating to architects. We have a magazine, Architecture Times, Space and People, which is having news and events related to council and other important events. The council also indulges in arbitration, training of architects. We also give awards to students for thesis, excellence in thesis, essay writing competition, documentation of architectural heritage. We have other publications like journals and other documents. We have entered into MOUs with BE, GRIHA, SEPC, IGBC for furthering the objects of the Architects Act. We are also conducting architectural design competitions. Recently, we have concluded 2 competitions for NHAI for bus shelters to be replicated all over India and also for intermodal station at Katra, Jammu. Practice of architecture in India. Registration as an architect is mandatory for a person to become an architect. Only an architect registered with the council or a firm can use the title and style of architect in India. Foreign architects can only work as a consultant or designer with an Indian architect after approval of central government for a specific project. Suppose if a person doesn't want to get himself registered with the council because he doesn't fulfill the requirement of the qualification and there is a residency requirement. You must be resident in India for 182 days. If you don't have those qualifications and if a foreigner has to come, that there is a specific project, a specialized project where a foreigner architect has to come, then he can work as a consultant or designer with an Indian architect. But he will not use the word architect with his designs and drawings because he will only be a consultant or designer. This is, I've already said, registration with each and every local body in India not required. In case of sole partnership, no registration of office is required, but in case of partnership firm, registration is required with registrar of firms and all partners should be architects. LLP and companies are not allowed to use the title and style of architect. Only individual architect or a partnership firm, they are allowed. So we are recommending that LLP should be allowed because the partnership and individuals have lot more liabilities. In case of any financial outcome, then individual assets will be under question. If somebody's liability is much more, then individual property will also come into question. So if you have an LLP, then your liability is limited. Like a company, you have your liability is limited up to your shares, which is there. So LLP we are introducing and we are recommending amendment in the Act. The LLP should be allowed for architects. Now I have some judgments related to practice of architecture, registration with local bodies, and role of architects in construction of buildings. The division bench of Delhi High Court and LPA number said that registration, local bodies cannot insist further registration. Here the case was related to MCD, Municipal Corporation of Delhi, that architects registered with the Council of Architecture are not required to get themselves registered or obtain registration from any local body. This judgment was upheld by Honorable Supreme Court of India. Similar, the Calcutta High Court also said that once an architect registered with the Council of Architecture, he is under an accountability from the Council of Architecture under the Act, and he is not required to seek any registration with any local body. Similar is the judgment of Honorable Bombay High Court. Then this is on employment of architects in government departments. The Madhya Pradesh High Court, there was a non-architect who was appointed to the post of architect, and the matter was taken before the High Court, and this High Court said that only an architect who is registered with the Council of Architecture can be appointed to the post, which are carrying the word architect, assistant architect, architectural assistant, chief architect, senior architect, whatever the nomenclature of the post is. Now there was a question before Guwahati High Court whether draftsmen and all can also work on the post of architectural post, and they were saying that this architect word is required only when we do private practice, and in government department is not required. The court said the proficiency as required of one carrying the job of architect is provided, controlled and maintained by the provisions of the Act. Same standard of efficiency is required. Maybe the building activities are carried by the state or private individuals. So this is a judgment which says that yes, the person for carrying on the duties and function of architect must be an architect registered with the Council of Architecture. now comes the Supreme Court judgment in civil appeal number so and so, where the Supreme Court said to promote an individual. This is a Mukesh Goel case, the recent judgment which we have all have been talking, where the Supreme Court said the practice of architecture can be done by any person provided he doesn't call himself an architect. The right use the word architect. Even here, the Supreme Court, what the Supreme Court appreciated is this: to promote an individual who does not possess a degree in architecture recognized by Act to a post titled architect and so, effectively violate the prohibition on use of title contained in section 37 of the Architects Act. Since the case was related to Noida, the Honorable Supreme Court said that Noida cannot promote or recruit individuals who do not hold a degree in architecture recognized under the Architects Act to a post that uses the title or style of architect. The Honorable Supreme Court further said that we have held that section 37 does not prohibit practice of architecture by unregistered individuals. It certainly does prohibit unregistered individuals from using the title and style of architect. Under the scheme of Act, only individuals possessing statutorily recognized minimum education qualifications can apply for registration architect. Registration as an architect under statute, this is the most important word, is thus a guarantee of possessing certain minimum education qualifications. Section 37 prohibits unregistered individuals from designating themselves or referring to themselves as architects. The consequence of this regulatory regime is that when an individual is called an architect, a reasonable person would assume that they are a registered architect under the Act and as a consequence possess the requisite educational qualifications and specialized knowledge associated with architects. This is what the Supreme Court appreciated while giving its interpretation of the Act. The Gujarat High Court in civil application number in the year 2020 said, it is clear that a firm of architect can use title if all partners are architects and not otherwise. The legislature, considering the fact that architects are engaged in profession and not in business, has enacted the Architects Act with a view to maintain standards of architects and to protect the dignity of architects. The Act was enacted at a time when everybody was calling themselves as architect, whether they were draftsmen or not, whatever the qualification is. So the object behind the enactment of the Act was to protect the general public from unqualified and underqualified people so that they do not bring disrepute to the profession of architecture. Then again the Supreme Court said, the High Court said, considering various aspects, it is clear that function of architects and civil engineers cannot be same. So this is an important recognition that both are different individuals, both possess different skills and different qualifications. Here is there is a case of Supreme Court only. It says an architect plays an important role in execution of building contract. We are discussing the role of architect in construction of buildings. The Honorable Supreme Court extracted Hudson's building and engineering contracts and said an architect is a person who possesses skill in architect of design of buildings to meet his client's need in the organization of contractual arrangements for their construction and supervision of work and contractual administration until final completion. It is the primary and vital function of the architect to create new ideas, amenity and design, and to set down those ideas on a drawing board. The architect is the captain of the ship. So this is the wording given in the book, that architect is the captain of the ship who is responsible, accountable, and who is the sole person who is managing where the project is going on, and will be the person to whom the owner will normally look if the design failure occurs. Now becomes the amendments in the architects. What is the remedy we are doing so that architecture profession is also protected and we can restrict the non-architects from practicing architecture? In 2011, the Parliamentary Committee of Rajya Sabha, they have recommended that the committee has also taken note of the fact that there is an urgent need for bringing in comprehensive amendments in the Architects Act in line with the advancement made, especially during the recent years. The committee observed that architecture, education and profession being very specialized, there is a need for giving protection to the architects and legal liabilities. The Ministry of Human Resource Development has also constituted a committee under the chairmanship of architect Dr. J.R. Bhalla, who was founder president of the council, and that committee has found following issues. Definition of architect. They said that we have to amend the definition of architect and we have to give the definition of architectural services so that we can restrict others from carrying on architectural services. Another is registration of architects and certificate of practice. What the scheme they have proposed, there will be a registration of architects and only those who have certificate of practice can practice. Like suppose somebody do not want to practice, so he may not seek certificate of practice. So this new concept is being proposed that we issue a certificate of practice to architects who want to practice architecture. A professional examination. Now world over professional examination is there, but in India or maybe Pakistan there are 2-3 countries where professional examination is not there. So whether you have done your degree from XYZ or whatever the university is, to have the minimum standard and competence to judge your skills and all, a professional examination is being proposed. This is there world over, whether it is US, UK, Singapore, whatever the country is. Scale of fees. Presently, architects do not have right to recover the fees like advocates. It is given in the Advocates Act that you have right to recover your fees, but it is not there in the Architects Act. So this is one of the proposed amendments where we are adding in the act that architects do have exclusive right to practice architecture and right to recover fees. Then about the registration of firms of architects, it is being proposed that the firms of architects be also registered by the council and LLP. So to ensure that only architects are there in those firms and they follow the norms and standards and the code of ethics which are prescribed by the council. To regulate the practice by foreign architects and foreign firms, some amendments are also proposed about them. They should first seek approval from the council and they should submit to the regulations code of conduct which has been prescribed by the council. Then only they should be allowed to practice architecture. What happened today, the field is open. Anyone can practice without calling himself or herself as an architect. So there has to be some restrictions. If we go abroad, even registered architects are required to collaborate with local architects. They are not given freedom to independently practice architecture. So these are the important amendments which the Bhalla Committee recognized and recommended to central government in the year 2015. In 2021, the council, recognizing the urgent need to amend the act after this Mukesh Goel judgment of Supreme Court, they recommended that no person other than a registered architect or a firm of architects shall use the title and style of architect and practice the profession of architect, including signing of building plans and related documents required for statutory approvals for the construction of any building and its related infrastructure. These are the amendments which we have given to the Ministry of Education, Government of India in the year 2021. And we have been pursuing with them, please do it. They are saying we are receiving some objections from the engineers and other bodies. Why are you restricting only to architects? So we are pursuing with them. Even we have written some 2-3 days back to the Honorable Prime Minister that these amendments are very important. These are required to protect the profession of architecture because nowadays the enrollment in the architecture field itself is going down looking after this judgment. So this judgment of Supreme Court is having far-reaching implications. It is affecting the profession. So this is my conclusion. Only an architect can use the title and style of architect to practice the profession of an architect in India, holds a professional competence and accountability for designing and planning of human habitat, can be appointed to architectural posts in government departments or private sector, or as a core faculty member in architectural institutions all over India. The Architects Act required amendment to provide exclusive rights to architects to carry on the profession of architecture, allowing architects to practice through LLPs and other modes where the liability of architects, the financial liability, not the criminal or other liability, the financial liability is restricted. Like we are also proposing indemnity insurance where you are protected from huge liabilities in case any mishap happens, and to deal with other related issues like enhancing the penalty for violation of the act. Currently it is 500 rupees. So anyone would violate and pay 500 rupees and he will go away. So we are saying there has to be some deterrent amount where the person fears, oh, the 5 lakh rupees, though it means something. So 500 rupees in the act, the penalty is nothing. I am quoting Swami Vivekananda ji, arise, awake and stop until the goal is achieved. So we all have to work towards the amendment in the act. Till that is done, it will be we have to work for it. Act was first initiated in the parliament in the year 1948 and it came after 24 years in the 1972. So we have to again work together, we have to again write representation and request the government that act is amended so that architectural profession, the general public and everyone is benefited. Thank you so much. This is all. Thank you. I thank you all for, especially the Manipur Architects Forum, for inviting me here, and whatever the knowledge information I have, I could share with all of you. Thank you.
Thank you. Thank you, Mr. Deepak Kumar. I think some very fun.
If any queries, I'll answer from here or whatever the way it is convenient.
Please be there because it's nearer to the mic.
Okay.
I think some very fundamental issues have been raised about the profession of architects. No, please sit down. Please sit down. Later on, yes. You can't just. Very fundamental issues. Just, I'm not a lawyer, nor am I an architect, but I had given a hint, which has been confirmed by Mr. Deepak. That is, how are we treating our profession of architects? Are we giving them the type of freedoms deserving of constructing not only buildings but aesthetic structures which can stay forever, like the history of architecture, isn't it? Now, what I strongly feel is that architects of India have to get together and see to it that something is done to this act. That brings me to the issue of Manipur and how we can reflect on this. That is, why non-architects? You see, in Manipur, non-architects are flowering like anything. Let me tell you, when I built my house, in 2001 or something, isn't it good? I mean, there were only a few architects who built a few houses. Benji was one of the bright boys then, Imphal Classic, and a few doctors' houses. I mean, these were iconic buildings where, including me, had to go and watch and see how it is so that my own house would reflect something of, modern things and all that. But what I'm saying is that organized architecture or architects' work in Manipur is very, very at the infant stage, so that even architects firms are finding it very hard to survive. It is exactly the place where, without proper regulations backed by the government, non-architects are going to take charge. In fact, they have taken charge of building houses and all sorts of structures in Manipur, which is very bad. Then, so the issue is, I think all of us have to reflect on what is the government doing? Who does the government employ as architects? If you look at all the government buildings, it's a shame, as was said by Anna, isn't it? It doesn't have character. It doesn't. In fact, most of the buildings built are by governments in Manipur. Private buildings have started just now. So when a government even builds a toilet complex, it needs an architect. What you have is, anybody and a draftsman also becomes an architect. That's the situation we have. So what should the government do to enforce on itself? He was talking of how, municipal governments or others, I mean, they cannot ask for, who the architect should be employed and all that. Council of Architects is responsible. You don't need to ask them to register again and all that. The fact is that all government and non-government offices believe that, architect is anybody. That's the main issue over there. Then, the issue is then, what is the role of Manipur Architects Forum? Just as any other forum all over the world, including Council of Architecture India. I think we need advocacy from this Manipur Architects Forum so that architects are involved in buildings. See that? If you do not advocate that you need architects, if public are not made aware that you need architects, otherwise you are going to regret it after 2 years, 3 years of building your house. That sort of an advocacy is not coming from the architects fraternity, which has been, helped further by the government, in building its buildings are not engaging architects as they should be engaged. Then the issue of building permissions, the way to make Manipur economic, this Manipur Architects Forum, or even in India, it's a small, this a case study which you can spread all over India, is when you are giving building permissions, isn't it? That's where we can, impose rules and regulations whereby it will become compulsory or incumbent on any builders, on any private or public builders, to build the right type of houses with the right type of regulations, right type of aesthetics and all that, isn't it? That is one. And then the last, ethics of architects. He was talking of issues of fees, isn't it? Why have we not rationalized fees in Manipur? We cannot, isn't it? A situation where it has arisen here, where budding architects have to run after clients, 10,000 to 20,000 thrown at you, and you just give a drawing finished. You have no other responsibility except dispatching this drawing to him. One go, no follow-up. What can you expect, isn't it? To such an extent that today, more literate people, who have the internet at their hands, they are browsing to the internet, looking at building plans and making their houses on their own. This is the pathetic situation where Manipur, Architects Forum has to regulate yourselves. You have to get together, frame your own rules so that you don't allow unscrupulous people, who just give a drawing and finished. You get 10, 20,000 rupees, isn't it? That's 90% of how the short of architecture that is going on. So these are issues that you need to address in light of the powers, functions, and ethical issues that has been raised by Deepak. So I open this house to give your opinions and reflect not only in the legalities and all those things, but at our own problem in Manipur, so that he, being an administrative officer of this Architects Council of Architects, can carry with him a good example of how architecture and architects have not, except in urban areas. In most rural areas, nobody cares, but we need to have architects in even the remotest part of the world. We have to dream for that. So we have to build a vision for that. So thank you, and please feel free and ask questions, give opinions, but keep it short and focused. Thank you, and please, it's open. Please address him. I'm not the expert. Please address him.
I get question say Mr. Deepak Kumar the address of the Azadawin Tawzage.
I'm not the expert.
No. I mean, I want to react to certain what you call observations which you have just now mentioned. Role of an architect. When enforce the within in Haina hybrid, this 10% chum but we are also in a very helpless situation because in Hajid is a building bylaws systems enforced out the Maраmoid. Signature has a mandatory or it is a big setback community. Aduna Hajiki Poto bylaws enforced overseas is very important because bylaws defines a working parameter. Aduna Sigi Posidi Taugadoni, whether the bylaw is correct or not, that is a different issue which can be discussed upon at a later stage. But implementation of bylaws is a very important thing. Adu Lerikan the parameters defined out in Haziribako. The state house Imphal city, the Maro in a Taurimiam, say, building typology, the density, the concentration, the Lambi, the everything is in a situation. Nothing is in order. To be very frank, nothing is in order. I think the correction to the Changi Haziribako, Adiki Potu, planning prerogatives, the period, Trasek, my period, Lacton, having issued on a different forum discussed the wind of the Changbra in the Kali, but
Has his views. What he's saying is that, you see, I hinted to all of them that you as a community have to take responsibilities. You have to come out and advocate. Now, what he's saying is that no, it's all right. What he's saying is that, look, sir, it's the government which doesn't, make its laws functional. See that? So we don't have control over this. So, your opinion, since you have all India level this thing, what we have been doing is that laws are there, people don't follow the rules. That's why I raised the issue of when the government itself does not follow your building rules. When the government itself doesn't follow the rules, public will not follow the rules. Okay, that is given, and I'm sure the issue of building laws not being followed is true in everywhere in India. That's why the building mafia is there. That's why the politicians are hand in glove with them, isn't it? So let's take it as a constant. What I'm saying is, let that not deter you from being morally correct and ethical in building your building. Don't leave the responsibility to the government. What I'm saying is, Architects Forum or Council of Architects, we have a responsibility on our part also. True. Isn't it? So what is your opinion on that?
So awareness about architecture and sensitization about the function of an architect and role an architect plays in the lives of general public or the government buildings is the first function, first step which needs to be there. The Architects Act itself was introduced as a private member bill. It was not introduced by the government. Late Mr. Pillu Modi, architect Pillu Modi, he introduced as a private member bill, and after so much years of pursuance, this act was enacted. So we all architects have to work with our own efforts and all. Government will not come. Even the government it's a complex of representatives of the people. So we have to pursue with the representatives of the people, our MLAs, MPs. We have to sensitize them, sir, this is where your intervention is required. We have to say what are the benefits, what are the drawbacks, where the government is losing public money. We are wasting public money by not hiring architects. So this is how sensitization is first thing, sir, and amendment in the act, and wherever we can do, the council is doing, and we need support and efforts from all, so that, because it is the person who's affected that only can seek medicine for himself or herself. We are also an arm of government. So architects have to come forward saying these are the amendments, these are the laws which we need. And the world over such laws are there, why not in India? So this is what I would say.
No, issue is, look, now we are going to have online, permissions going to be granted. When it becomes online, you will not be able to do any harassment, right? Up to now, it's the town planning or whatever government agencies, right, giving the permission to build buildings. And we just, the architects themselves, even in my case, in order to we bypass all laws, bylaws, so it has become a system whereby you submit your this plan, housing plan. It will be all informed, but when you actually build it, it's according to your convenience. This fraud has been going on up to now. So, is it not your responsibility as architects? Is it not my responsibility as a citizen building a house to ourselves follow the rules, right? So if you architects do not follow the rules, encourage the people, just send in this thing, clear it so that you can make a bank loan. I mean, so I'm just putting forward a moral issue to which you and me are all responsible, isn't it? So Architects Forum needs to come out, advocacy, educate the people in different ways. Holding a meeting here, let this spread to the rest of this thing. I think you go to anywhere who are following the rules, even in Chandigarh. Are you following the space between two houses? Exceptions are being made. I don't know, advocacy. So please, any other questions?
And even sir, the regularization of and condonation of illegal construction. That is, if our building bylaw says there will not be any regularization, there will not be any condonation of illegal construction, no illegal construction would happen. It would fall like the Twin Towers in Noida. if such steps are taken, because where the clause is there, it will be regularized or the illegal construction would be condoned after payment of some money, all builders and all feel I'll pay the money and get the illegal construction done. So these are the things which are affecting the profession.
But the situation in Imphal right now is like we have to have a very conducive environment to build right. And I'm questioning that environment.
Whose responsibility is it to correct that environment? That's the fundamental question we must ask now.
That is true. We should be playing a fair amount of what you call responsibility for that. But also, like as I said, you just now mentioned that online building permission system is going to be implemented soon. That's a very good move. We all appreciate it. But in ground reality, see, last 2 weeks back we were also discussing about minimum areas of what you call plot, which are, what should I say, not in a very proper order. I mean, some plots which has been deemed to be recognized by the government as a minimum plot area, it may not be possible to kind of do a house project on such a piece of land. So issues like that are there. So what I'm saying is a very conducive environment is required to do good practice.
I'm sure Deepak will answer to that also. I don't know, he's a lawyer, but let me answer it from a common man's view. Okay, and let me answer it from observing worldwide phenomenon of how beautiful cities are built, except for Chandigarh. You see that any city over time, you're talking of the small space, kya karega? The history is that, you see, in building new buildings, okay, outside Greater Imphal, when you're going to spread, it is there that strict laws have to be followed. Imphal will get costlier and costlier and costlier, so that like in any other cities, big world cities, unplanned, but it becomes planned later on. When there is development, when there are multi-million or billion investors who are going to buy, land in Imphal, at very, people are going to move out, isn't it? It will become residential houses are not going to get away. So it is when that city is restructured, the old city, some change may come there, not all changes. But my point is, as a layman, when you observe, it's only when the new buildings are being made, stricter and very, very strict laws have to be put in, so that the architects as a profession can shine and flower.
Like how it is happening in Guwahati right now.
Let's be sincere.
Size of like plots one can really not control, because it depends on the economics and the financial capacity of a buyer. The government has to think of all. If a person is having this much of capacity, he will purchase that plot, larger plot, other larger plots. So really, there can be no interference from the architect side or from the council side and all that. You have only this size of plots or that size of plot.
No, but logically, when you build a house, you should be having a minimum recognizable area with a recognized width. Only then you can build a house. Like for instance, if I ask you whether you can build a house on a 20 by 40 square feet of area, how would you answer to that?
Sir, off target, sir, and depends. I'm saying if there is an existing construction, a person having meager resources, he would be happy having in 10 by 10 plot also. It depends the financial capacity, but really we can't do anything with this.
Let us come back to target now, as Gita has said. Yeah, I think today's discussion should be at the macro level rather than at the micro level. It's a matter of policies. It's a matter of your profession, how to protect your titles, which simply means we have to be better architects, very simply put, isn't it? So given these legal challenges, how can we function as a group of professionals so that we contribute to the state's development, isn't it? That's the main idea. So please, other opinions.
We have to create our demand by showing our works, because showing our best works, showing that this is the difference in the work of an architect and non-architect. This is how we can attract people that yes, I have to go to an architect to have a good, beautiful, aesthetic and planned building. We have to create the demand for ourselves.
In simple terms, when we say protection of title and style, let us not take it literally. You don't want any other people to work in this area. We don't want civil engineers to be constructing or planning or conceiving about building designs. That's a minor issue. Major issue is protection of title, means what is meant by an architect, what are the do's and don'ts that we must do, what are the ethical issues involved, and you have a social responsibility. That is the advocacy that I'm talking about. So let us go at the bigger level. Protecting the title means if I am titled as a professor, I have to act, do things becoming of a professor. So what can we do to protect our title? Let us not go at the literary thing. Let us go at the legal, ethical, and practice issues. Right?
Yes.
Have you, ma'am, please? Yeah. Yeah. So, Ming Khang,
Hello, sir. My name is Architect Eva Rajkumari. So when we talk about protection of title, I have some queries. There are certain government and non-government organizations. They invite for competitions and tenders. So when there are specifications like we only invite registered architects, and then if this organizations, they take up non-registered architects or interior designers or any other line, is it like authentic, or can we file a case against them?
This is totally a violation of the Architects Act. When we are inviting an architect, or we are saying only registered architects are invited for this project, that means only registered architects are eligible to participate for the particular project. And if they select, or if they consider the applications, the requests, the proposals, the tenders of other people, this is totally illegal.
And what is the process we can file against them?
One is that you file a writ petition in the High Court. First is to make representation before the concerned authority that what you are doing is violation of the Architects Act, which the Act defines an architect as a person who is registered with the Council of Architecture, and the person which you have selected or which you are scrutinizing is not an architect. So this is a violation of the Act. Please mend your ways. We are architects, or you can say who is an architect. These are the architects available. They can approach council to seek list of architect, whatever other help they want. But not that when you are saying we are inviting only architects and we are selecting somebody else. So this is a violation of the Act. You can bring such incidences to the notice of Council of Architecture. We will also interfere there. We will write to such organizations, please stop this. This is illegal. This is not as per the norms. And if such person who is selected, he is representing himself or herself as an architect, we can write to that person. We can also prosecute such people. If they are not architects and they are participating as architects, that is also an offense, punishable offense.
Sir, another question. So when we talk about professional ethics, there are certain professions other than architects who define themselves as architect in social media, or when they introduce themselves or any other platform. Is there any act against them, or can we?
Misrepresenting anywhere in India by a person who is not registered as an architect is a punishable offense, whether it is on website, social media, anywhere. The law says that no person shall use the title style of architect or misrepresent himself as an architect unless he is registered as an architect with the Council of Architecture. So if you find any person who is misusing, misrepresenting, and he is not an architect, please do point out to Council of Architecture. We will take up with them. We will stop them or we will prosecute them.
Thank you, sir.
So sir, I'm Michael, architect Michael. So can you please elaborate regarding the this one penalty to those who practice architecture without being registered as an architect?
Yeah, penalty in my earlier presentation also said it is only 500 rupees. So
any imprisonment thing?
Yeah. If a person repeats, then 6 months imprisonment is there.
Okay, 6 months.
6 months imprisonment is there. There are two sections which provides penalty. One is section 36, which says that no person shall misrepresent himself or herself as an architect or use such words or letters which suggest that person is registered as an architect. If he does so, he is punishable with a fine of rupees 500, and if he repeats, then it is 1000 rupees with imprisonment for 6 months. So this penalty part is quite less compared to other provisions, because unless the penalty and deterrent provision is there, more stringent deterrent provisions are there, the people will violate. Because just by spending 500 rupees, they earn lakhs of rupees.
Okay, thank you, sir.
Good afternoon, Mr. Deepak. My name is Architect Rosen. The presentation which you have shown, it was very informative. So, like, and second, there is one question I would like to raise. What can be done from our fraternity, architect fraternity, and general public, that the architecture can be only for architects?
Yeah, we have to pursue the government. Here, in case of architects, it is central government, not the state government. So we all have to pursue the Honorable Prime Minister, our Honorable Education Minister. We are under Ministry of Education, Government of India. So the Education Ministry itself has to get convinced, yes, the profession needs to be protected. Other people have to be stopped from practicing architecture. So public opinion, a mass opinion has to be created that yes, the architecture profession has to be practiced only by architects, not by other people. Other people are bringing disrepute to this profession, though they are not titling themselves architect, but they are bringing bad buildings, they are bringing bad names to the architects, because general common man understands every person who is engaging designing, planning, that he is an architect, but they are not. So the public will has to be created for bringing a prohibition on architectural services by a person who is not an architect. So this is all. So we have to work towards, we have to send representation to the parliamentarians, to the Honorable Prime Minister, to the Education Minister. Okay, please bring such amendments which already recommended by Council of Architecture. You have to just support the Council's initiative. It doesn't look that it is Council of Architecture doing it. It is the demand of the profession. It is today's need that the architectural services are restricted only to architects, like medicine, chartered accountant, company secretaries, everywhere the profession is defined. The work, what is medicine, what is chartered accountancy, what is company secretary, what their role, it is defined in the act. In our act, it is not defined, it is left open. Because at that time, architects were not there. Maybe 700 or 1000 architects were there in the year 1972. And we have given our recommendations, but the government, because the number of other civil engineers, others is more, and architects is still less. So their objections do come, no, please don't restrict it only to architects. So we have to create a public opinion that yes, architectural services should be done only by architect, because they are accountable, because they have the training, they have the competence, and if an architect does anything, he can be barred for life. If a civil engineer or if a draftsman does some mistake, he will only pay some penalty, but he will not be barred for life. But in case of architect, he is professionally accountable. The Council of Architecture can bar him forever. So these are all things which architects, as a body, we have to bring to the notice of the government, because it is a public will for which a law is made. We have to point out that this is an evil, and to cure this evil, a law is required.
Does the population or the number of architects in India, does it mean something to move the process, like?
Yeah, already we have to just show. We have to just show the amendments which I have just shown. The proposal we have already. It is already before the government. So we have to write mails. We have to write representation to the government. Yes, this proposal is given by Council of Architecture. Why government is not acting on that? The government should act because it is in public interest. It is for the betterment of general public, for their building, their construction. It is for common men, not for architects. We have to say these amendments which are proposed, they are for the betterment of common men, because they will get a qualified and competent person who will design their house. So this is all. We have to create a public opinion and pressurize our representatives who make the law that yes, please, this is an urgent matter where your attention is required. You bring the bill to amend the Architects Act so that architectural services are restricted only to architects.
Okay, up to some point, as per Architects Act, it is already written the style of architect. So as per my perspective, I think that style of architecture doesn't mean that we are fashion designer or designing something. It's clearly mentioned that the person who architecture, style of architecture means style of architect means
the way of carrying the profession,
carrying
the profession. We argued this before the Honorable Supreme Court. I was personally present when this matter was being argued, and the Attorney General who argued against this, he said ki presently the number of architects are very less. If I say only architects will design, where there will be no construction in villages, there will be no construction in small towns and all. Well, he took some other sentimental view, drawn the attention of the court, instead of saying what the law says, what the requirement there, or what are the international laws are there. He says, my lord, if you impose a complete prohibition on practice of architecture by upholding that only an architect will practice, then all buildings in India will come to an halt. This is the view Attorney General of India gave before the Honorable Supreme Court. So this, because judges and whatever the view they take, but we have to come to give a comparison. It is there in medicine, it is there in law, it is there in company secretaries, it is there in chartered accountants. Why it is not there for architects? The number will increase according to the demand. If demand is there, definitely people come join the architecture profession.
I think you have raised a very fundamental question which your Council of Architecture needs to take into account. I just realize now why the Supreme Court, in such a labored way, isn't it? Very labored, very hard to convince me. But in a very labored way, it tried to say that your profession is not like these doctors or this thing. In a very labored way. The argument was that you involved so many other experts, right from the draftsmen to engineers to electricity, internal designers, so many people, It raised some issues, which are not convincing, but true to so many extent. But he's raising so this raises a main issue of organization. When he's saying that we are too few, when the Supreme Court says or government says that too few. So we need advocacy also. We need to organize ourselves on trade union terms, but which we are not being able to do because of our small numbers. But yet, so the issue is the second part which we have neglected. Architect and architectural firm. In Manipur, architectural firms have come up, died. Come up, died, isn't it? Git is trying to revive it. Some sort of a firm. In a firm, you will have that critical mass of experts, draftsmen, interior design, whatever, isn't it? Then people will have faith in that firm. But what we are now having in Manipur, or as he hints in all of India, is freelance architects, individual architects who cannot, instill public confidence that you alone can do justice to my house. So we have certain organizational problems. That's why probably being a common man, but feeling the pulse, I now, put to him this fundamental question. How do we organize ourselves as architects so that this issue of advocacy only one person cannot do unless we have a, So the issue of architects alone working, freelancers, architectural firms. I believe, I don't know, in anywhere in the world where big architectural things are going to be done, it will be firms. Can we have rules and laws by which architectural firms are encouraged to work better on bigger projects and so on? You cannot neglect these individual freelancers, but the issue of architectural firms in the rest of the world, freelancing architects, I hope you understand the issue, please.
The scale of firms can be like we are recommending that we have LLPs. So partnership firm, there is a limitation that you have only a small number of partners, but we are recommending that we have LLPs, where limited liability partnership, where the number is more. In other parts of the world, even companies are allowed to practice architecture. They allow corporate practice. But we are saying if we have corporate practice, the small architects, they may not be able to get the work. So we are only recommending that we have LLPs. And as regards how do we organize ourselves, though we are having like Manipur Architects Forum is there, let us work with Council of Architecture. We all together can work. IA, Indian Institute of Architects, is also there. So we can collaborate with them so that our joint efforts, our voice, one voice is there to work for our rights and to get relief from the government.
Hello, my name is Murangtham Gautam. I would like to ask you if you can throw some light on the ethics of our conduct of our profession. What are the ethical issues, and what are the? Yeah, I believe it must be there in the manual. However, I haven't read it, so thank you. That's all.
Of Section 22 of the Architects Act, we have prescribed the Code of Conduct and Ethics for Architects. I'll read out what are the ethics for architects. To ensure that his professional activities do not conflict with his general responsibility to contribute to the quality of environment and future welfare of the society. Apply his skill to the creative, responsible and economic development of his country. Provide professional services of a high standard to the best of his ability. If in private practice, inform his client of the conditions of engagement and scale of charges and agree that these conditions shall be the basis of the appointment. These have been elaborated now, which is the manual which we have prepared. Here the detailed guidelines about the contracts, about the fees, how to calculate the fees, these are all given. The Government of India, Ministry of Finance has prescribed general financial rules for selection of architects. So this manual is in line with those guidelines. Then another is not subcommission to another architect or architects the work for which he has been commissioned without prior agreement of his client. Not give or take discounts, commissions, gift or other inducements for introduction of clients or work. Act with fairness and impartiality when administering a building contract. Maintain a high standard of integrity. Promote the advancement of architecture, standards of architectural education, research, training and practice. Conduct himself in a manner which is not derogatory to his professional character, nor likely to lessen the confidence of public in the profession, nor bring architects into disrepute. Compete fairly with other architects. Most of the complaints which we received is on this clause only. Because an architect gets a project for X fees and other architects comes and he works for X minus 1 or X minus 5. So here the most complaints which Council of Architecture receives. The earlier architect says the new architect has taken up of the project without my NOC, without payment of my fees. So most of the complaints which Council of Architecture receives on this account. Next is observe and uphold the Council's condition of engagement and scale of charges. This manual is conditions of engagement and a scale of charges. So please do go by the manual, please do read it, go through it. Not supplant or attempt to supplant another architect. Not prepare designs in competition with other architects for a client without payment or for a reduced fee. Not attempt to obtain, offer to undertake or accept a commission for which he knows another architect has been selected or employed until he has evidence that the selection, employment or agreement has been terminated and the other architect is given his fees. Comply with the architectural competition guidelines of the Council. When working in other countries, observe the requirements of code of conduct applicable to the place where he is working. Not have a partner in his firm who is disqualified from registration by reason of the fact that his name has been removed from the register of architect under section 29 or 30. 29 name is removed when a person gives false documents or something. Section 30 is when a person is punished, an architect who has been punished by the council. So an architect should not have that person as his partner. Provide their employees with suitable working environment, compensate them fairly and facilitate their professional development. Recognize and respect professional contribution of his employees. Provide their associates with suitable working environment, compensate them fairly and facilitate their professional development. So there's a whole list is there. These are available on our website. and they are also given in manual also, it is there. And in manual we have added some more. There are some proposed professional ethics are also there in the manual, which are yet to be incorporated in the main part, which is gazetted part.
I think at least I would personally request you to address one issue on the matter of ethics, that is the issue of intellectual property rights, especially on trademarks and copyrights. In Manipur, anywhere you will see that each architect's creativity in design or style is repeatedly being stolen and replicated. So please say something on that. This is a very vital issue of ethics.
What happens, sir? Actually, as per law, as per the Copyright Act, the author, the person who designs, he is the owner of the design. But in the government projects everywhere, or we do not write such clause in our agreements. So an architect should understand the contract act as very well. The contract has to be drafted very well to understand that the designs and drawings prepared by him or her shall be his. It cannot be used by some other architect or some other client, or by the client itself for some other project. So the contract which you enter with the client should be, in the manual we have given, there are 3 types of contract. One is concise, then second is standard, third is comprehensive. So all clauses have been incorporated in the manual. We have given template in the manual. This is how you should enter into a contract, wherein we are also given hints that copyright, you will write that copyright is of the architect only. How the client can use it for construction of building, for education and research, and it has to be reproduced. Then it has to be done with the permission of the architect only. So copyright, architects must, with their agreement, they must write that copyright rests with the author, that is the architect, and it cannot be used by any other person, the drawings.
Hello. Good afternoon. My name is Dhanajit. As mentioned in the Act itself, through the definition of the architect, so it says that anybody who gets registered with the Council of Architecture can be called as architects. But I would like to question is that what are the various qualification other than the degree that those who can register under the COA?
Under the Architects Act, there is a schedule of qualification, list of recognized qualification. One is the degree imparted by a central or a state university, and others are some diplomas given by so-and-so XYZ institutions, and there is a membership of Indian Institute of Architects. This is Indian. In foreign also, there are degrees given by the foreign authorities. There's a whole list which is there under the Architects Act. So mostly, and the main is degree. A degree in architecture, bachelor's degree in architecture.
In the real life scenario in Manipur here, the state government is favoring and awarding many of the government projects to a particular self-styled agency. How do we go about it?
Sir, agency means, is it a company, is it a firm, is it an LLP, what is the entity? Agency means
they
what?
call themselves as architects, but they are not.
So, you have to come forward, file a complaint. It is who will bail the cat. So somebody has to take the blame on him, or become the target, but he will be doing it for the betterment of profession.
Right now, sir.
Either the forum will take it. If it is forum, that is better, because no individual come to the light, and
So-
the forum can definitely file a complaint. And first off, I am saying you bring it to the notice of Council of Architecture, where you all are safe. You do not come to the light, or no prejudices happen against the concerned person who's making the complaint.
Right, sir.
All such instances, please bring to the notice of Council of Architecture. It is my wing, my department only, that who's taking of all such complaints and writing to all concerned authorities, issuing them legal notices. And finally, if things do not work, we go for prosecution.
So I am the first rate who will bail the cat.
Thank you, sir. Thank you. It is, you are doing for the betterment of profession and for the enforcement of the Architects Act.
Yeah, but I think you have to bail the minister also. You see, and you're a very, very good minister. I tell you, he's a no-nonsense minister. He was very, just tell him, why should any fly-by-night architectural firm or a pseudo firm capture everything? So please bail the minister. I tell you, he'll help you. Please. We have quite some time more. Please. We have 20 more minutes. Let's.
Hello. Sir, myself, Bumiras Kaisam. Actually, my question is there any action which council can take up against the person who is an architect, but he's working under some company who is not registered as an architect, and he's doing all the signature for that firm. So is there any action without going to the High Court or Supreme Court, directly action taken by the council? So is there is the process, tell us the process.
I understood your question. What happened, this matter about architects working under a company is a sub judice. There is already a judgment. One architect from Delhi, architect Sudhir Bora, he filed a case in Delhi High Court against about 1,000 companies which have been registered by either architects, non-architects, but they are all practicing architecture. The High Court said that these companies cannot call them architects, and like other people, non-architects, they can practice architecture. It is the self-regulation. It is our self-regulation that we don't go for such companies, but it is a matter of livelihood also, that unless we go there, where we earn. So it is a catch-20 situation ki how we will work, but companies cannot themselves title as architects. It is only the individual or the partnership firm. This matter, there is an appeal. The High Court said that companies can practice architecture. We have filed an appeal before the division bench saying they cannot practice. A legal entity cannot call itself as an architect. They cannot solicit business. So how the High Court can held that the practice of architecture can be done by companies? But now the Supreme Court judgment, another judgment which came in between, that is affecting the case. We may lose that case. This is what, because the Supreme Court says that anybody can practice architecture provided he doesn't title himself or herself as an architect. So the amendment in the Act, Architects Act, is the need of the hour, and for that we all have to work. We have to create a voice, one voice, that yes, please amend the Act. This is affecting not only the architects, it is affecting the general public, because under the guise of architecture, everybody is becoming an architect, and they are playing with the general public, their buildings, their expectations.
So if we can't take action against the firm, so can we take action against those architects who are signing the documents?
See, taking action against architects will only affect architects. So question is, now the High Court itself is saying, yes, companies can practice, so we can't take any action. So until and unless the matter is decided, companies can't practice. So we will write one letter if the judgment comes to the Ministry of Corporate Affairs, Government of India. Please wind up all such companies which are practicing, whose aims and objectives is to practice architecture. But unless the law becomes clear, whether they will practice or not practice. So this law is in limbo right now, because our appeal is pending before the division bench of Delhi High Court. We have challenged, yes, this judgment of single judge is not correct, where they are allowing companies to practice as architects. So as of now, the law is not clear on this subject. But definitely we all architects, we are only, one of us will only work in the company, so we can advise them, we can guide them. You form your own company and give your consultancy, not as an employee but as a consultant.
Hi everyone, I am Yaifuba. Sir, I would like to ask you, just clarify one thing, that in your presentation you had mentioned that for our profession we don't have anything that guarantees our collection of fees, service fees. Collecting of service fees is a big thing, I mean big hassle here. So what I want to know is, if we signed a contract, with the help of the contract, can we legally at least be sure of, so I think using the contract it should be a good, practice that should be done by everyone then.
Yes, if there is a clause in your contract, then contract is enforceable. We can bring a suit for recovering the fees. It is called specific suit for recovering the fees. But your contract must clearly lay down. It is not what normally architects are doing. Is one friend engaged him, or through friend you get introduced to XYZ, and you even don't have an agreement with the person. You were given some X token amount, and afterwards you are working, and when the project is going to complete, the other person says bye-bye, I don't require your services. So contract is the first thing. we advocates first get signed the wakalatnama from the client and then take his or her file. Without that, no work. So this should be there. This should be the practice of architects. You first get signed a contract with your client that these are your duties, these are my duties, these services or these documents you will provide, like ownership documents, the land requirements, or there is no dispute, nothing else, because tomorrow the neighbors also come against architects. Okay, he has trespassed into my plots. A lot of complaints are such complaints where the neighbors are complaining against architects, where they have no locus trying to complain against the architect because he was engaged by other person, not by the neighbor. So the contract should be such that we define the duties, liabilities, the functions of architect, the deliverables which an architect will give. Deliverables are also very important. These are the drawings which I will give as part of my duties. If you want additional, you have to pay this much of fees. Yeah, in the manual it is there. This manual, it's actually guiding you, giving you all important documents. This manual is there, even how to raise your bill. That specimen bill is also there, where you will put your stamp. That is also, we tried that it is from a layman's angle, a person who just comes out after passing his BR's course, how he will run his practice. We try to guide in such a manner. It is there.
Afternoon, sir. This is Tilisha Konsam. I have a question regarding your amendment 2015 regarding certificate of practice. So what does it really mean? And also, for example, for a registered architect who has not been practicing architecture for the last, say, 4-5 years due to various reasons, does it mean that it's the end road for them and legally? So can you please elaborate on this? Thank you.
This is only a proposal. What we are planning is, you first get self-registered as an architect, and only those who intend to practice architecture. But one, like Madam Anna, she's in civil services, so she may not require the practice certificate of practice, but she can use the word architect. So the difference between using the title architect and actually practicing the profession. When we are saying certificate of practice, we are going to introduce that you must undertake such and such or such number of projects, such number of workshops, such number of trainings in order to get your registration renewed. That is missing in our act. It is there world over. They do not give license or renew your license unless, like doctors, it is there. You must undergo some workshops, some trainings, some projects. Like for the past 5 years or 10 years, if you have not done a single project and you are coming for renewal, they won't do it. They'll say you work with some architect for some period, then you come. So as of now, this certificate of practice is only a proposal. It is not that as if we have done it. It is only a just a proposal.
So what stage is it in right now?
Basically, we have given this proposal to the government, but we have this another single amendment which we are saying only architects should be given the powers to give certified building plans and all. That is the most urgent provision to tackle the Supreme Court judgment which we have given to the government. And those are the comprehensive amendments, because an act amendment takes so much of time. It is referred to the Parliamentary Standing Committee, the public views and suggestions are asked. So we are saying if a single clause is amended first, this section 37, where it only restricts the title and style, and if it restricts the people from submitting building plans to the municipal corporation, to the development authorities, we are saying you restrict this work only to architects. Instead of saying architecture as a whole, we are saying restrict the submission of building plans and all related services to an architect. So this will in a way restrict other people from submitting their building plans. Nobody will go to a non-architect and then go to architect just for getting his building approved from the concerned local authority.
And so regarding this, can we make a soft sort of a humble request that I personally know a lot of architects who practice for a while and then due to various reasons, personal reasons or other sort of reasons, that they stopped for a few years, but then they want to come back. But again, if you're doing this 2015 amendment, it'll be a little hindrance for them. So can you soften some sort of...
As of now, they can do. As of now, there is no bar because the act is not amended. It is only a proposal. As of now, there is nothing. As of now, anybody whatsoever, the current existing law says ki renewal, whosoever pays the 600 rupees to the council, his registration will get renewed. But this is a proposal. This proposal is there in the developed world. they are already functioning like this. You have to have practice architecture. You must know the current practices, current laws. If you are not in practice for 5 years, 2 years, 3 years, then at least you must work with an architect who will, at least you are in touch with the profession, so that then only the license is renewed. But as of now, there is no proposal. As of now, an architect who, the registration is open to all who possess the recognized qualification and payment of fees. So is the case with renewal. You can get it renewed. Renewal is annual, and it is also one time. Like it is, you don't have to pay the fees again. Only just your certificate will be endorsed after 10 years.
So, here, actually, I think the people must have brought this situation up. Actually, our moderator, sir, he had also mentioned that we as a professional should uphold our ethics and our standards. But what happens is, see, since the council gives certifications, registers new architects, young architects who just passed out from their college, who has a degree, they are given the certificate as well, which is good because even I benefit from it. But the thing is, what we all know, that what is taught in the colleges versus what is actually being practiced is a very big difference. So since it is a technical service, I mean, it is basically these knowledges are earned through experiences, or you earn it under an expert. I mean, are there several queries like this, like what can be done to kind of, it's not that I don't want them to grow, it is just that they need guidance for them to mature and be able to actually. Otherwise what happens is, when they go around, when these young bloods, they go around looking for work, they sometimes kind of get they are not able to deliver the expected, they might damage the name of the architect, instead of, while because they will be making mistakes. There is, even I made mistakes, I mean, but luckily I was working under my father. So likewise, I think there should be, I mean, is there a concern from the other states as such? Because that's I'm quite curious.
Yeah, the professional examination which I was talking, it is there world over. What they do after completion of your qualification, you have to undergo, in US it is 2 years, in UK it is 1 year, and in India it is only as part of course curriculum, like 6 months training is there, where something is taught. You have some hand-on exposure to what is being handled by architects. So what we are proposing is that after completion of your graduation degree, you undergo 1 year of practice and then appear for professional examination. And the professional examination will not be judging what you have already been taught in your degree course and all. It will judge you on your professional liabilities, responsibilities, some environment laws, building bylaws, and the universal thing which an architect should know while practicing in India. So that proposal will take care of all these issues. Council is fully aware, yes, this is happening. And what happening is, those non-architects, they are misusing the young architects. They get their signed on payment of petty amounts and use their drawings and their name to practice architecture. This problem, we are fully live to this. And basically it is the attention of the government. The way once we could convince the government, yes, this is the problem in the society, this is a problem which is affecting the profession of architecture, this is a problem which needs to be addressed immediately, then all things will get cured. And already there are 2 committees. One is the Bhalla committee of the government, and another is even the parliamentary standing committee. They said, yes, we need to make law, we have to amend the Architects Act immediately, but somehow our current government, I don't know when they'll take up, but we keep on pursuing the government. Yes, these are the laws which we required. We were trying to have MRAs with foreign countries like Singapore, Australia and others. They were also saying, in our country we need professional examination. It is not there in India. Their number is less and our number is more lax, so they are afraid, we can't have MOU with you because you have lakhs of architects and you don't have such a standard which we maintain. So these are problems which need to be addressed immediately, so that we have a comparable standards and our architects move internationally also.
Hello, sir. Excuse me. Hello, sir. Excuse me. Taking the advantage of you coming here, thankful to you. Like we have sent a letter regarding the violation of architect, selection of non-architects as in the post of some assistant architect. Yeah. So can you please tell us what are the process been done and anything needed to be done from our forum side or from the council? So can you please tell us the
Yeah, we have written to the government that the person appointed by you is not an architect and the post is of architect. We have also enclosed the copies of judgment to them, and again we'll be pursuing please remove the person from the post of architect. If at all nothing happens, then prosecution is the last weapon we have. Similar was the case in Odisha, where a person was appointed in the housing board as deputy chief architect, whereas he was an engineer. So just coming before here, we have issued a legal notice and given judgments, ki sir, please remove him. Given copy to the chief secretary of the state and the chairman of the housing board, ki please remove him, because he's not qualified and competent, and this is clearly in violation of the Architects Act. So we have to be actually aware what is happening, vigilant. Yes, some non-architect is appointed to the architectural post. This is violation of our rights. We are the only qualified and eligible person to get appointed, whether X, Y or Z, but only an architect.
So how do we know that after your instructions, have they taken any actions or anything?
What I suggest is the forum can interact instead of individual on this issue, because it should not happen that we are acting in hand in glove or something like with some individual. The forum can write to a council what action has happened or what has happened. Otherwise, you will otherwise come to know that this action has happened. To prosecute somebody will pass a resolution from the full council. Resolution is there, and the matter is brought before the metropolitan magistrate. Even that is an issue, because some courts say you have to go to the jurisdiction of the accused everywhere. So that is quite difficult for council, like to come to Manipur, to Gujarat, to where. So we have convinced now a judge saying like CBI, ED and other agencies, we can also file cases in Delhi. Let the accused come to the jurisdiction of Council of Architecture, to the Delhi, and this is how we will prosecute them.
So like if we send our this one query, if there is no reply from them, so okay, so council will deal with that.
Yes, definitely.
Okay then. Thank
Okay.
you, sir.
Well, ladies and gentlemen, we have 3 more minutes. So the last question, I give you the privilege for that. Before.
The first is regarding this registration with each and every local body in India. You said that it's not required, but every local body is taking registration fees. How do we go about it in the state?
Sir, bring this to the notice of the council again. The central government Ministry of Education has written 3 letters. There are judgments of also there that an architect is not required to get himself also registered with local bodies. The registration with the Council of Architecture is sufficient. So any violation of the act, any problem you feel that this needs to be addressed, please bring it to the notice of Council of Architecture, and we will take up such issues with them. Now
they don't call it registration fees.
Yeah, they call it online impediment or something. They have introduced new concepts. It is happening in Bangalore. Well, everywhere in the name of online system, they are asking 50,000. In Rajasthan, they are asking 50,000, 20,000 rupees registration fees. They are saying it is since the online building approval system has come. So now it is not registration as an architect. It is only for online building approval. So we have to basically question everything, that as per the act we are not required to get registration, but for online, if they are asking some petty amount like 100 rupees, 500 rupees, which is administrative charge just to get impaneled, so that your drawing, they know who is the architect here, or they may be creating a master data where they know who are the local architects available for sanctioning. Well, we are also developing, I think we have already developed a API wherein the local bodies can check who is an architect, who is not, online from our website. Recently, very soon we will share that data, that link with all the local bodies, that you can verify the architects from our website instead of you maintaining a list or any implement or anything.
So this happens everywhere despite of this thing. Then another question is, there are many public agencies engaging non-architectural firms for architectural works. How do we tackle that?
So as I earlier said, you please object to them. If they don't buzz, then we will file complaints against such things. The requirement should be that this work is advertised only for architects, and the selection is done with person
No, but
who's.
they don't mention it architectural firm. They call it designer firms.
Yeah, that is actually, sir, lacuna because the architectural services, which includes designing, planning, and everything. So unless the word architect is there, we can really stop that organization, that department that you have only intended to engage architects, and now you are engaging non-architects. Unless the law specifically prohibits, the act is amended to prohibit non-architects from practicing architecture. Design consultant, because of Supreme Court judgment, the recent judgment, it has created a vacuum that anyone can practice architecture and all. So we are on it, but until and unless that is done, that will have to bear with that. Because once the eligibility is there, architect, and then they appoint a non-architect, then it is questionable, 100% questionable, and we will question it.
So until and unless they mention the word architects, we cannot do anything. So I think we must be very clear on these lines.
I am open to any more questions.
So when we say anybody can practice architecture, so what do you define practice as? Is it just the execution or even the approval of the drawing, architectural drawings? And if it's not, then up to what extent can we question the non-architects for professional ethics?
A practice of architecture, actually it is not statutorily defined in the Architects Act what includes the practice of architecture. So basically practice as an architect by an architect is the need of the hour, and really we can't say this is ethics, and this is not part of any ethics. If a non-architect is giving any services as an architect, it is the client who is suffering. There is no prohibition on the practice of architecture. There is no definition of what is architectural services. Until and unless we define architectural services like audit services, medicine, what is medicine, practice of medicine, this is there given in the act. And in the legal profession, they have said that no person can appear before the courts unless he is registered as an architect. They have not defined the legal profession, because by defining we restrict the meaning, the definition, the services. So by not defining, so something has to be done for defining architectural services, that we define. We give a definition that it includes, when we say not an exhaustive definition which covers, we say it includes designing, planning of spaces and whatever all submission of building plans before this. We are doing it, but somehow this is not happening. We have to work more hard for this, and Act amendment is what the council is working on very hard.
So I think we should close up this session. I have only one or two words to say to sum up the thing. In India, the profession of architects is yet to mature because of the smallness of the market. We are such a big country, but the market of architects is smaller. Coming down to Manipur also, our market is even smaller. But the future market is so huge. So it's for us architects to create that market. For that, you have to be ethical. You have to know your business, your profession. And the last thing is that we need to get organized and advocate. Only when Manipur Architects Forum advocates architecture's need, then only this market will expand. You have to carry the government with you. You have to convince the government and enforce. Architects Forum of Manipur has to enforce the rules that government itself makes, so that your market as architects is expanded. This is one. Number two, any architect or any profession has to adjust to the local context, especially the value systems. In the Northeast, we are Southeast Asia. We have a value system where we don't follow formal rules so much as in other parts of the West. We follow informal route, this contracts. So when Yaifaba was questioning his difficulties of getting fees, you see, our culture is such that if you are a doctor, or if doctors are a different lot, they will have their fees put up on the wall. But for architectures, I mean, it becomes unethical from the people's value point that you start bargaining on money before you start talking about architecture or building the house. But this cannot last long, isn't it, Yafaba? I mean, you can sign contracts with some big boys, with big builders, isn't it? But it's very hard for you, to sign contracts before you actually begin the work. This is the cultural context. Benju was one of the exceptions, He had the temerity or the courage to say to one of my university friends, Professor, you've got a high level of pay. You are not ready to pay me 50,000 rupees for my work. Please. You see, you need to put down your feet. And of course, to be able to do that, to impose institutional parameters in a very informal society like Southeast Asia or Northeastern region, you have to do something as a profession to enforce these rules, isn't it? You cannot carry on doing informal work, Your client, you almost feel like begging to them for your fees. That is why firms are getting out. So you need to get more organized. The last point is the issue of architectural firms. Unless you have functioning, vibrant, and moral architectural firms big enough, where even young people like him, Yaifaba, or any other young boy can have his apprenticeship, can cut his teeth, isn't it? Then only you will become freelancers who public trust. We need these architectural firms to emerge. And I think it is in the responsibility of senior architects like Ega, Joy, Gate, including Budavari, you or Bikram, you people have the responsibility to organize our architects so that your market is expanded, so that you carry the government with you, isn't it? And so that as a profession, you adjust to the local context so that India Council of Architecture of India's own laws are enforced here. With this, ladies and gentlemen, thank you. On my part, this conference is closed. I leave the rest to the organizers. Thank you so much.
In the end, I would like to also say thanks to the Manipur Architects Forum, Geet Kumar sir, Benju sir, Krishan Kumar sir. Thank you so much for inviting me and having such a good interaction and dialogue with all of you. Thank you so much.
I would like to take this opportunity to thank our moderator, Dr. C.H. Priyaranjan Singh, for such a smooth session and also for filling in the gaps in between. Also, I would like to thank our key speaker, Shri Deepak Kumar, Administrative Officer, Council of Architecture, India. Now, this concludes our today's program. Before we leave for the sumptuous lunch which is waiting for us, I request everyone to kindly join us up front in an organized manner so that we can commemorate this moment with a group photograph. I request everyone to head outside. Sorry, the space is a little small here. And also thank you everyone for joining us today again. Thank you.